Good afternoon. My name is Vicki Redgrave, and I'm Vice President and General Counsel at Technology Concepts and Design, Inc. TCDI was founded in 1988 to provide business and government clients with advanced application and system design services. Today, we are recognized as a leader in the e-discovery and litigation technology markets, serving law firms and Fortune 500 companies that operate in some of the most complex legal environments. We are very pleased today to present this webinar program entitled Reforming Discovery, the Seventh Circuit e-discovery pilot program, use of the Seventh Circuit e-discovery principles to improve your discovery processes. I am very pleased to introduce our panelists for today's program. First, we have Honorable James Holderman, Chief District Judge for the United States District Court, Northern District of Illinois. Chief Judge Holderman has been a United States District Judge in Chicago since 1985 and has been the Chief Judge of the Northern District of Illinois since July of 2006. During his more than 20 years on the bench, Chief Judge Holderman has presided over numerous cases in all areas of federal jurisdiction. During his tenure as a United States District Judge, he has also served by designation on judicial panels of the United States Courts of Appeals for the Seventh Circuit in Chicago and for the Federal Circuit in Washington, D.C. Next, I'd like to introduce Honorable Nan Nolan, U.S. Magistrate Judge, United States District Court, Northern District of Illinois. Judge Nolan was appointed as a United States Magistrate Judge for the Northern District in 1998. Magistrate Judge Nolan is a member of the Advisory Board for the Sedona Conference and a member of the Georgetown University Law Center e-discovery Advisory Board. She is the chair of the e-discovery committee overseeing the Seventh Circuit Electronic Discovery Pilot Program. Magistrate Judge Nolan regularly speaks on the topic of electronic discovery at conferences throughout the United States. Tom Lidbury. Tom is a litigation partner with Mayor Brown, specializing in trial work and electronic discovery. Tom is a group leader of Mayor Brown's electronic discovery practice and has extensive experience helping large companies develop their electronic discovery programs and manage electronic discovery in large cases. Tom is a member of the Seventh Circuit Electronic Discovery Committee and serves on multiple subcommittees, including as co-chair of the Early Case Assessment Subcommittee. Finally, we are pleased to be joined by Alexandra Buck, Senior Counsel and Director of e-discovery and records management. Alex is currently an adjunct professor at Loyola University of Law, where she teaches cyber law. My thanks to all of you for joining us today. Chief Judge Holderman, again, thank you for being with us today. I'd like to begin with you and ask that you provide us with an introduction to and your thoughts regarding the Seventh Circuit Pilot Program.
Thank you, Vicki. First, I want to thank you and your company, Technology Concepts and Design Incorporated, TCDI, for all of your assistance in putting this webinar program together today. Your involvement has been invaluable, and thank you. The Seventh Circuit pilot program was initiated in response to the continuing concern among lawyers and business leaders about the undue burden and cost of electronic discovery. What Magistrate Judge Nolan, who chairs the pilot program committee, and I initially did, was to invite the assistance of lawyers, both plaintiff and defense, as well as in-house counsel, private practitioners from large and small firms, government counsel, judges, bar association representatives, and experts in the field who we knew were interested in helping to develop solutions to this continuing problem. At our first meeting in May 2009, it was decided by the pilot program committee that we as a group would initially develop guidelines and principles we could all live by relating to three areas of electronic discovery: preservation, early case assessment, and education. The idea was also to test these principles in actual cases. What was contemplated was that the pilot program principles were to be designed to augment the Federal Rules of Civil Procedure dealing with electronically stored information, and to try to achieve the goal of rule number 1 of the Federal Rules of Civil Procedure, which is to secure the just, speedy, and inexpensive determination of every action and proceeding. The subcommittees were formed and chaired by members of the bar. The Preservation Subcommittee is chaired by Jim Montana of Better Press. The Early Case Assessment Subcommittee is chaired by Karen Quirk of Winston & Strawn and Tom Lidbury of Mayor Brown, who is on today's panel. The Pilot Programs Education Subcommittee is co-chaired by Mary Rowland of the Hughes Sokol firm and Kate Kelly of the United States Attorney's Office. These members of these subcommittees, through much debate, compromise, crafting, and drafting, developed the Pilot Program Phase 1 principles we are discussing today. The process was completed in September 2009. Then, in October 2009, United States District Judges, Magistrate Judges in the Northern District of Illinois began implementing these principles in pending cases on a case-by-case basis, with the cases being selected for Phase 1 by the presiding judge of each case. Also, as part of Phase 1 of the pilot program, the committee established two more subcommittees, the Survey Subcommittee, which is chaired by Joanne McMahon of General Electric and Natalie Spears of Sun and Shine Nathan Rosenthal, as well as the Communications Outreach Subcommittee, which is co-chaired by Alex Buck of Abbott Laboratories, who is also on today's panel, and Steve Tepler of Edelson McGuire. We will soon, in Phase 1, administer surveys to the judges and lawyers involved in the selected Phase 1 cases to gather information and receive feedback for making improvements as we move forward. In early May 2010, we intend to issue a report about our experiences and findings in Phase 1 of the pilot program at the 7th Circuit Bar Association meeting held in Chicago, and then move on to Phase 2. In a nutshell, that is how the pilot program Phase 1 has progressed until this point. I applaud and thank the pilot program committee members who donated a substantial amount of their time as well as their energy and enthusiasm, way beyond Judge Nolan's and my expectations, to creating and articulating these principles that we are discussing today.
Judge Nolan, can you provide us with your insight and thoughts on the pilot program and its genesis and goals?
Thank you, Vicki. At the heart of the pilot program are two principles. One is cooperation, and second is proportionality. I'd like to say a few words about each of the principles. Cooperation is really, you will hear as we go on today, is part and parcel of every one of the principles. The Federal Rules of Civil Procedure have always required that parties meet and confer before filing any motion. However, this practice has been somewhat ignored, and what has really developed is a culture of discovery that unfortunately has become very harsh and costly to the parties. When the rules were amended for the ESI rules in 2006, Congress made an effort to increase the requirements. But the real change came when the Sedona Conference in 2008 wrote what is really a very simple but profound statement in their cooperation proclamation. They wrote, and the same is true in our principles today, that cooperation is consistent with zealous advocacy. This is really a sea change on the way discovery has been conducted. Secondly, I want to talk for a minute about our second fundamental principle, which is proportionality. Again, proportionality is part of Federal Rule of Civil Procedure 26, but we have put it front and forward, and the real, I think the significance in the principles is that proportionality is even more important with ESI because e-discovery tends to generate such large volume of materials. In Principle 103, we are encouraging parties to narrow the scope of what their requests are and to intelligently frame their requests and responses to deal with the real issues of the case. Here again, the process requires cooperation between the parties.
Well, let's begin with how the principles apply when a case is just beginning. Tom, we're all familiar with Rule 26F, which requires that council meet and confer. Can you explain how the pilot program complements or adds to the Rule 26 requirements?
Sure. Thanks, Vicki. Rule 26F2 provides that the parties must discuss any issues about preserving discoverable information and develop a proposed discovery plan. The committee felt that that was great, but it didn't give a lot of guidance to people about what issues they should be discussing and what should be in the discovery plan. And in practice, most of the committee members felt like this was often ignored or treated at such a high level that the parties didn't really have a meaningful discussion about the issues that they should be thinking about and they should be raising with the court early on. And it might be better resolved early rather than waiting until it was too late to fix the problem as opposed to talk about sanctions. So the principles do a number of things. We try to identify specific topics that should be investigated and understood by council before they come to the Rule 16 conference, and that they should address in a meet and confer process before the Rule 16 conference. And we're going to get into more of those details as we proceed through this. And the other aspect to it was, in addition to identifying and trying to guide the discussion about what issues could be thought about early on, was to incentivize a more open exchange and sort of give an incentive to the calls for cooperation and actually get people to see the potential benefits of cooperation. And one part of that is that the aggrieved party, if there's something that you could have brought up early and discussed and worked out, and you don't, the court may not hear you later when you have a problem about it. And that's part of the way the principles try to incentivize people to sit down and actually exchange information rather than try to put it off and ignore it. Principle 2.01 is the lead-off principle about this. It lists a number of things, and I'm going to talk about A1, 2, and 3 a little bit. A1 requires that the parties talk about identification of relevant and discoverable ESI, the scope, and Part 2, the scope of discoverable ESI, and Part 3, the formats for production of ESI. Throughout the principles, we have all of these topics then covered in more detail. So this is the general pronouncement that people must consider and discuss these issues. And 2.05 is, which we'll get to more detailed later, talks about how you talk through the identification issues concerning what ESI is discoverable and relevant. 2.04 gives guidance as to preservation and what issues should be thought about early on. And 2.06 gives some more guidance on format issues. And again, we're going to get into all of these principles more as we proceed through this. 2.01b is the part where I talked about the incentivization. B says that issues shall be presented to the court at the initial status conference. And other issues that may not be able to be identified that early on also must be brought up as soon as possible thereafter. This is trying to tell people you can't ignore an issue and then wait for it to become a strategic advantage to bring it up and then complain about it. So issues that can be reasonably identified must be identified and brought up, and the potential downside to this, sort of the unstated but implied risk of noncompliance with 2.01b, is that if you do game it and don't bring up something you could have, the court may not hear you later when you raise it, months or years into the case. Principle 2.01c adds some guidance as well. It explains that the parties must review, the counsel and party must review and understand how the client's data is stored and retrieved. If you're going to have this exchange that we're talking about, it's necessary that you actively investigate and understand the client's information systems and how they store and retrieve data. Otherwise, a meaningful discussion isn't possible.
Well, I've heard a significant amount of discussion about a new role being introduced into the process, the creation of an e-discovery liaison. Specifically, Principle 2.02 calls for the designation of an individual or individuals to serve in this role when a dispute concerning preservation or production of ESI occurs. Alex, can you tell us more about the liaison role?
Sure, Vicki, thanks. The committee really wanted to come up with a way to guide people to give the courts and each other a true exchange of knowledge. A lot of times, if you don't have a designee who knows the systems, you're asking a lot of questions, and you have to say, you know, I don't know the answer to this right now, let me get back to you. That's a lot of resources and time that are wasted. So this e-discovery liaison could be one person or a team of people, depending on the issues in the case and the disputes that arise. But really, we thought it would be a consistent face, if possible, for the courts and the parties. Another impetus for this role was really to get the experts talking to each other, and in that way you can actually move the case along and probably avoid a lot of disputes.
Well, again, Rule 26 doesn't speak to liaisons, but why did the pilot program drafting committee decide to include this role? And can you share with us a little bit more about the role's intended function and whether this is a position that the parties will need to fill in every case?
Sure. So really the idea behind it was to encourage practicality and efficiency. Let's get the information across the other side into the court that they need in order to focus the scope of preservation and production. The role itself could really be played by anyone who either has the knowledge or can gain that knowledge. It could be somebody in-house. A lot of corporations do already have that role in-house. It could be outside counsel. It could be a third party that you hire to learn your systems. It is required in every case where there is an actual dispute, but frankly, it's probably a good idea to designate a discovery liaison even before you get to the disputes, because you're likely to avoid those disputes if you have the true experts talking to one another.
Judge Nolan, is the e-discovery liaison mandated?
Yes. I think the simple answer is yes. What 202 says, that in the event of a dispute concerning preservation or production, each party shall designate. So to me, that is a mandate. I'd like to say something here, though. I think Alex articulated why the e-discovery liaison is so important to the parties. But this, I believe, is also going to be very helpful to the judges, because when the judges are confronted with a dispute, almost every one of these disputes are fact-specific. And all lawyers are not as knowledgeable as the lawyers on this webinar. It would be very helpful to me when I am trying to quickly understand the client's system to have someone there from the company who would be able to articulate for me what the client system is.
Principle 2.04 addresses the issue of preservation of electronically stored information. Alex, can you tell us what the committee was trying to accomplish in this principle?
Sure, Vicki. So we want to discuss preservation starting broadly and really set a default for the parties to say, here's what you really need to think about, and early on, what you should preserve and what you don't necessarily need to preserve. We also wanted to encourage early communication about what each party should preserve in order to help focus those preservation efforts. The lack of early communication generally leads in very broad preservation. We also wanted to discourage discovery about discovery. So if we encourage the communication, we're hopefully going to discourage disputes and motions later on regarding what the preservation efforts were.
Does 2.04D provide an exhaustive list of what needs to be preserved?
You know, we did not intend this to be an exhaustive list, rather some examples of the type of data the committee thought really shouldn't be at issue in preservation in most litigations. But this is also a good heads up to litigants that if this type of data described in 204D is important to your case, you better address that early with the other side. It's really meant to give some guidance on what the committee members thought generally should be out of scope of preservation.
Alex, do you believe that the 204D list will help litigants reduce litigation costs if the areas identified are excluded?
We really do. For example, if you're just talking about deleted slack space alone, if you're talking about an image of a hard drive, generally speaking, deleted slack space gets rid of anywhere from 50% to 70% of that data. That's a huge savings on the bottom line. And I just wanted to sort of throw an example out there just to demonstrate how a gigabyte of data translates into actual dollars. I got these numbers from really just thinking about general large corporations. These numbers are actually fairly conservative. But for example, if we assume company XYZ has an average of 2.5 gigabytes per custodian, again, if any of you are familiar with corporate data sets, that's an extremely small number. Let's also assume that company XYZ has 10,000 people on hold for various litigations. If company XYZ were forced to simultaneously collect and process all that data for all litigations, it would cost roughly anywhere from $12 million to $60 million just to process that data. Then when you take review into account and the time that it takes to review 1 gigabyte of data, you're talking about over 33,000 days for one attorney to review all that data, costing the company probably over $60 million just to review it. And you haven't even produced the data yet. So every gigabyte of data that we can cull down, that we can say is not part of this preservation and production effort, is immediately going to affect the cost of litigation, and it goes directly to that proportionality principle that Judge Nolan mentioned earlier.
Well, Judge Nolan, this discussion brings up the question about discovery on discovery. Do the principles contemplate taking discovery on a party's preservation efforts?
Well, I think the answer is it depends upon the case, but 2.04b addresses this very issue. And what 2.04b says is that discovery concerning the preservation and collection efforts of another party may be appropriate, but if used unadvisedly can contribute to the unnecessary and expense and delay and may inappropriately implicate work product and attorney-client, which then can also increase the cost. Accordingly, here's what the committee said in, I think, a very balanced approach. They say that prior to initiating such discovery, i.e., discovery about discovery, a party shall confer, have a meet and confer, and talk about two specific issues. One is the need for the discovery, and secondly, are there any alternative means that a party may use rather than exhaustive discovery? Again, the committee, I think because it was such a balanced committee of both plaintiffs, defendants, clients, what they did in the end is, even if the parties agree to that, what the rule says is nothing in the rule exempts deponents on merits issues from answering questions. So we're not taking anything away from the party, but this rule's intent was a more direct, hopefully cheaper and quicker way to figure out the preservation without months of motion practice.
Well, Judge Nolan, Principle 2.03 addresses preservation requests and orders. What guidance does this principle provide to litigants regarding a party's preservation obligations?
Well, I am very proud of the committee on the work that it did on preservation in general. I think that anyone that's familiar with the amended rules know that the amended rules did not cover in much detail preservation. the early ESI cases that came out, almost every one of them dealt with a preservation, either a failure to preserve, and actually the heaviest sanction cases were about preservation. I think that what the attorneys on our committee did is try to give some practical guidance going forward. Preservation has many sources, as lawyers know. This is not just a statutory, there is a common law requirement, there is an ethical requirement, and there are the rules requirement. I think what these preservation rules do are take all three requirements into consideration, and I think that they actually try to help the parties to fashion their requests and responses in a very specific way, and again, it's all done through cooperation. They are saying that the two parties can sit down and have an agreement what is the proper preservation for this case, not for any other case, but very fact-specific. And if the parties can agree to it, it is certainly going to save money, save time, and hopefully acquire a juster result.
Tom, can you discuss what the party that is requesting preservation of electronically stored information needs to do?
Sure. 2.03a takes the position that parties should not issue vague, overreaching demands. They're disfavored. The committee felt that there was a practice that may have been sort of fixing itself to some degree, but it was still out there, where there was a tendency for a party to send a very general, keep everything kind of preservation demand at the beginning of a dispute that didn't give any real specifics about that might be helpful in terms of actually figuring out what should be saved, and that led to a equally vague denial or refusal to comply with those overbroad requests, and the parties never actually got down to the meat of questions like those put forth in 2.04d that Alex talked about that would really be useful to talk through. What 2.03 provides is that the party asking for another party to preserve information should offer specific and useful information that will help the opponent identify the subset of information that it should preserve, as opposed to keep everything and we'll figure out what's relevant later. So some of the things that would be helpful are listed in 2.03. If you can flesh out the factual and legal issues, we have notice pleading in federal court, so complaints can be somewhat vague. If there's some more information you can give about your claims or about the issues that you see coming up or the types of evidence you believe are going to be relevant to your claims, offer it up, and that way the other side can intelligently try to better figure out who are the key players who have information. The courts have pretty much endorsed the key player approach as opposed to keep everything and sort it out later. They've really endorsed the approach of working through a key player approach where you try to identify what's relevant through who you realistically expect to be involved in those areas. So help, if you can, offer some information about what your claims are so you can do that. If you know of specific employees or agents who you think ought to be on the list for preservation, tell the other side. Don't just expect them to figure it out and fault them later for not noticing, if you know. Flesh out the time period. If you can offer more guidance on what the time period you consider relevant, or for what kinds of information you think which time periods are relevant, again, that will be helpful. And then finally, there's just a catch-all. If there's any other useful information that you can think of that will help the adversary identify what it ought to keep, share it. Now, this is, all that said, nothing in here requires a party to make a demand, but we're trying to give guidance if you're going to make a demand as to what would be actually useful in creating a dialogue back and forth that's helpful and productive.
Alex, what guidance is provided by the principals to a party that is responding to a preservation request?
Principle 2.03c addresses what a recipient of a preservation request should do to respond. I want to point out that there is no requirement to respond, and lack of response is not a waiver, and that's the first thing that Principle 2.03c addresses. The committee thought it was important to encourage recipients of preservation requests to say, look, here is what is reasonable for us to do in response to your preservation request. We encourage people to identify the specific steps they're taking. If they've identified key custodians, to share that information with the other side, and really to identify any disagreements with the preservation request, or alternatively to say, this is what we're not going to do as our general course. And certainly to bring up any issues that were not raised in the original preservation letter, perhaps also asking certain preservation issues back to the original party. So it really encourages the responding party to take control of the preservation and to be transparent or translucent, if you will, and share information, but to keep the dialogue going.
So we've covered preservation, so let's go back to the parties' meet and confer obligations and talk about the issue of identifying ESI. Rule 26F discusses ESI briefly. Principle 2.05 addresses the identification of ESI more specifically. Tom, what should be the parties' goal on this point?
The goal here is to get the parties talking about each other's plan for using technology to cull the data. Alex talked about how huge the initial set of data can be, and it's obvious in cases where the data set is that gigantic that there needs to be some technology used to bring it within a manageable size for human beings to look at. So one of the things to talk about is deduplication. This has, I think, become pretty standard. There are still questions about whether you're going to dedupe within a custodian's collection, but not across the entire data set, or if you're going to do across the entire data set. If there are concerns about which form should be used, that should be discussed and worked out. File type filters are another part of another technology that can be used to cull down the data. You could eliminate system files, you can eliminate music files, and you can think of any other number of files types that can be filtered out in certain cases. In some cases, maybe that you can't use any, but maybe in some it makes sense. Date restrictions are also a format or a type of search that can be done to limit it down. You can limit it to sender and receivers as opposed to any mention of different terms. Or you might be able to focus on certain senders and receivers of emails. Of course, Boolean searches we're all, as lawyers, pretty familiar with, and there are all sorts of ways you can use that to narrow the data. And this encourages people to talk about that and share the search terms and try to figure it out. So another thing is the potential use of advanced culling technology. There are types of searching like Bayesian concept clustering or thesaurus-based concept clustering or searching, and these are all things that should be leveraged if possible, and the parties should talk about how they can use their objections to using them, sort that out, and if something can't be worked out, then go and see a judge and figure out what's reasonable.
Well, you use a lot of terms. One thing I'm going to go back and ask for a little bit more of clarification for people who might be listening that may not be familiar with it. Can you tell us what deduplication is?
Sure, sorry about that. Deduplication is when you have a large collection. Let's say you've collected email from 100 custodians within a company. If you use deduplication technology, you can eliminate, let's say 5 people were on an email. You can eliminate 4 of them and keep 1 copy, because all 5 of them are going to have that email in their or potentially could have it in their email storage areas. Deduplication will identify those and cut it down to 1. You still have the email. You just don't have to review it 5 times, and the person who's receiving it doesn't have to look at it 5 times. So that's the basic idea.
Makes sense. Judge Nolan, how do you handle disputes on issues such as the development of search terms?
Well, as the law is right now, under 26F, parties are required to address certain issues. Search terms are not one of them. And one of the things that I think is going to be so helpful, from what Tom just gave the list, if you were writing very quickly, he talks about 10, 12, 15 things that are possible to be able to discuss at the conference. I would like to say very specifically that if the parties could agree on search terms, I think it has two advantages. And I want to use a case I'm supervising right now as an example. I have a very complicated patent case. I have lawyers on both sides who are very knowledgeable in ESI, so that helps. But these folks started, and what they did, and I think what happens in a complicated case, is that you may have different phases. So the first time that they tried to agree on the search terms, the phrases were actually too broad. But they tried it. They came back. They said, we've got to do a round two because now we know much more about who the custodians are, what the terms are. And when they did it the second time, they hit it almost perfectly. The downside, so obviously those folks saved, there wasn't one motion involved, they saved time. Maybe it took a little extra time because of their work, but in the long run, they saved time. The second advantage is there are two new cases in which when the parties were not able to agree, the judge was put in the position, the judge picked their search terms. And I don't think that's what most clients would want, would be a judge sitting there opining on what the company's search terms were. So there's a real advantage to having an agreement.
Tom, Rule 34 addresses the production format for ESI. What do the principals add on this point?
The committee felt that we couldn't add too much to Rule 26F on this. We made a couple incremental concepts. We tried to advance a couple incremental concepts. We don't elaborate on what is a reasonably usable non-native production format for various types of common document formats. But we do offer some guidance on encouraging requesting parties when they're asking for databases, for example. We encourage them to leverage existing database features for reporting out of that database and accept a report, whether it be in an Excel electronic form or a printout, doesn't matter, but accept what the database is capable of putting out. It can be very complex to try to recreate a database. You can get into issues of authentication when you do receive a database in raw form and recreate it and crunch numbers in it and then produce a report out of it. You're going to have problems with the other side who originally produced the real database wanting to authenticate what you did and see if it's real. So there are a lot of issues with it. It may be necessary in some cases. We aren't taking an absolute view, but we try to encourage people to think about, maybe a report out of the database is at least a good starting point and maybe even a decent ending point. We also take the position that a party producing documents that are in a native format that is not text searchable, for example, the traditional paper, or an electronic image that's essentially an electronic version of paper, like a non-searchable TIFF or PDF. Take the position that you need not upgrade that to an electronically searchable form for the other party's benefit. However, we do encourage that the parties cooperate and think about cost sharing with that kind of information because it can be mutually beneficial to both sides to be able to search and review that stuff electronically.
Well, Tom, Alex, thank you for sharing your thoughts and the practical guidance on application of the pilot program's principles. Judge Nolan, as the chair of the committee, can you tell us what's on the horizon for the committee?
Yes, Vicki. As you know, the pilot program has two phases, and we are just about concluding phase one, or we will by May 1st. I think one of the unique aspects of the pilot program is that in addition to developing the principles, we are going to survey the participants to actually test out the effectiveness of the principles. So in a very short period of time, the judges and the lawyers who have participated in phase one will receive a survey. In this regard, we were very fortunate to have two organizations, the Institute for the Advancement of the American Legal System, which is an organization in Denver that's connected with the University of Denver, and the Federal Judicial Center agreed to work with our survey committee, and they have drafted, I think, a very professional and effective survey that are going to the judges and the lawyers. When we receive the results of the survey March 1st, the survey will then, our committee is then going to look at the principles, and if any of the principles have to be modified as a result of the comments, then for phase 2, we will have basically a modified phase 2. I also, particularly here, I would like to thank the folks at the Institute in Denver and the FJC because their efforts have been almost nonstop and full-time.
Finally, Chief Judge Holderman, can we expect more information on the pilot program in the future?
Yes, Vicki. On May 3rd, 2010, at the Seventh Circuit Bar Association annual meeting, we will be presenting the committee's report on Phase 1. In that report, we will review and analyze the information obtained from the surveys that we will be administering shortly to the judges and lawyers involved in the cases applying Phase 1's principles. After that analysis and presentation of the Phase 1 report, we will make adjustments in the principles and standing order based upon the snapshot of information we derive from Phase 1, and then move on to Phase 2 on a broader, more informed basis as to the improvements to be made to achieve our goals. Meanwhile, our Education Subcommittee will continue updating the pilot program materials on the Seventh Circuit Bar Association's website and provide educational podcasts discussing specific issues in connection with electronic discovery questions. One thing is clear from what we have done so far, and that is that cooperation among counsel early in the discovery phase of any litigation is a necessity and is consistent with zealous advocacy now in the 21st century. The hardball approach of ask for everything and give nothing is an antiquated relic of the past century. The new era is here, and the Seventh Circuit Electronic Discovery Pilot Program is a step toward meeting the 21st century's litigation challenges in the United States. I want to thank the participants in this webinar, Alex Buck, Tom Lidbury, and Judge Nolan. And again, thank everyone who has served on the pilot program committee as we continue this endeavor. I also want to thank everyone who has logged on to this webinar because you are a part of the solution that we need to achieve the goals.
With the time that we have remaining, we'd like to answer some of the questions that we've received from our audience so far. And the first one is to you, Judge Nolan. Can you tell us how many cases that you currently have in the program and what's been your experience so far?
Well, in Phase 1, we've had 81 cases so far, and we are considering Phase 1 to be basically a snapshot of the program because we had such a short period of time. My personal experience with I have 14 cases in the program is that I can report not one of the parties has filed a motion during that period of time. So I'm declaring it a smashing hit.
Well, Phase 2, you spoke about Phase 2 as kind of the next movement forward on this. Is that going to operate any differently than what Phase 1 did?
I think so, Vicki, because Phase 2 will start approximately in June, and it will last for a full year. I'm expecting that we're going to have a much broader participation of judges, hopefully judges outside of the Northern District, because this does encompass the Seventh Circuit. And I expect that more of the attorneys are going to know about the program, that we're going to have a broader base of lawyers also. And we then, at the end of Phase 2, in June 2011 or May 2011, we'll do a second survey with the Federal Judicial Center to test out the program after it's operated for almost 2 years.
Alex, if you're in a case right now that's not been selected to participate, or perhaps you're outside of the Seventh Circuit, how can you use these and apply these principles to those cases?
Well, I think really anybody can use these principles. It does not matter if you're part of the pilot program. They are meant as guidance, and you can certainly refer to them and use these principles to help move your cases along. In fact, I'm aware that several corporations and law firms have already trained their attorneys on these principles, and at least in the corporate setting, they are encouraging their attorneys to use these principles as guidance to really move things along. And they're also training their outside counsel on these principles, even though they may not have a case even in the Seventh Circuit. I think they can be very helpful for litigants anywhere.
So, Tom, as one of the committee members and a member of a couple subcommittees as well, can you give us a little bit of a sense of what the whole process was like in putting together these principles?
Sure. You know, the process was we had lawyers from all stripes, defense bar, plaintiff's bar, government lawyers. Every different perspective was represented, and there were passionate views all around, and not every issue was easy to work out. Not everyone, you know, I should say no one got everything that they wanted, but I think everyone came up with a framework that we could all agree on as a fair process for e-discovery. And more importantly, I think we all worked hard. You know, there's a tendency to try to negotiate to stalemate so that the provisions said nothing, and we saw a lot of that, we felt, in other local rules that had been adopted out in other places. And we worked very hard not to do that. We tried to actually resolve a question, even if it didn't always come out our way, but provide some guidance and move the ball forward. And it was a really productive process, and I think everyone involved feels good about the framework that we came up with.
Well, again, I'd like to thank all of our panelists for their participation this afternoon. On your screen are useful links where information regarding the pilot program can and will be found. Also, the questions that we were able to answer today are being captured, and they will be used in the preparation of frequently asked questions, which will be posted on the Seventh Circuit Bar website in the near future. Finally, CLE credits have been approved for the state of Illinois, and we also intend to file CLE applications with several other states, so please visit the TCDI website for additional information on how the CLE accreditation can be obtained. Again, my thanks to our panelists and to all of our audience who's listened in today's webinar.